aspirants, a very warm welcome on the YouTube channel of Analyst IAS. Our today's topic for discussion for focus of the day is the right to private property. So we will see why in news, what is right to property in the original constitution, what was it, then what was 44th Amendment Act of 1978 और इस एक्ट ने क्या क्या चेंजेस लाए, then we will see सुप्रीम कोर्ट के कुछ इंपॉर्टेंट जजमेंट्स जो प्रॉपर्टी के राइट के ऊपर हैं. Then we will see all of the things in a gist. After that, we will be solving our today's prelims practice question. So let's start. Why in news? So the Goa bench of the Bombay High Court has recently held that the daughter's right to the family property will not extinguish. It will not end even if the dowry has been provided to her at the time of her marriage. Now let's study what is the right to property. So right to property, basically it guarantees a person's right to possess private property unless it is explicitly barred by the law, unless it is taken away by the law. Now most constitutions in the world recognize this right except वो constitution जो communist government जहाँ पे framework बनाती है. Even the Universal Declaration of Human Rights mentions this right to property. Now the Constitution of India originally provided for the right to property under Articles 19 and 31. These were the fundamental rights. Article 19, it guaranteed all the citizens that they have the right to acquire, a right to hold, right to dispose the property if they want to. And Article 31 also said that no person shall be deprived of his property save by authority of law. Now came the 44th Amendment Act of 1978. इसने right to property को fundamental right से remove कर दिया, जो उसकी list थी. एक new provision Article 300A add हुआ, was added to the Constitution, which provided that no person shall be deprived of his property saved by authority of law. Now 44th Amendment Act था क्या? So it deleted the right to property from the list of fundamental rights and it added Article 300A to the Constitution and said that no person shall be deprived of property except by the authority of the law. Now, several amendments were made to the Article 31 and eventually Article 31 को abolish कर दिया गया था. Article 31A, B, C, they still exist. There were two articles in 1949. Article 19(1)(f) and Article 31, but both the articles were deleted from the Indian Constitution by the 44th Amendment Act or this Act. Article 31 with subheading of the right to property, इसको हटा दिया गया था इस एक्ट के द्वारा. So Article 31 clause 1 has been shifted to the Article 300A as a replacement insertion of Chapter 6 of the Part 12 of the Indian Constitution. What are the important Supreme Court judgments? So, सबसे पहला Supreme Court in the bank nationalization case, it held that there remains the right to reasonable compensation for property taken over by the state. So, reasonable compensation का right दिया था इस case में. At the same time, the court also said that upheld the doctrine of eminent domain, by which the state can take away private property for public use if it wants to. Then Jilu Bhai Nan Bhai Khachar case of 1995. In this, the Supreme Court held that the right to property given under the Article 300A of the Constitution, ये basic structure का part नहीं है. It is only a legal right. Then there was the case of recent case in which Rajinder versus District Collector, Vellore case of 2022, in which the court said that the state has no right to interfere in the citizen's private property unless it is done by the authority of the law. Then in January 2020, Supreme Court in the Vidya Devi versus State of Himachal Pradesh case, it said that right to property was a human right. And in this case, the court also held that the state cannot use the doctrine of adverse possession to take away the property of its subjects without following the proper due process. So state को एक proper due process follow करना पड़ेगा property लेने से पहले. In a gist, let's see. So first of all, in the original constitution, 1950, fundamental rights were there in the part 3rd, Article 19(1)(f) and Article 31. Later on came the Amendment Act of 1978, 44th Amendment Act. इसने इसको फंडामेंटल राइट की लिस्ट से रिमूव कर दिया. आर्टिकल 300A पार्ट 12 में एस्टैब्लिश कर दिया गया एंड इसको एक लीगल और कॉन्स्टिट्यूशनल राइट दोनों बना दिया गया. आर्टिकल 31A, 31B, 31C, they have been retained, still they are in the constitution. Then related सुप्रीम कोर्ट जजमेंट्स हमने देखे. जीलू भाई नान भाई खाचर केस देखा वर्सेस स्टेट ऑफ गुजरात. हरि कृष्ण मंदिर ट्रस्ट वर्सेस स्टेट ऑफ महाराष्ट्र. Then we saw Vidya Devi versus the state of Himachal Pradesh and other cases. What are the implications? So now the property can be limited, it can be shortened, modified without requiring a constitutional amendment through ordinary parliamentary legislation. Moreover, it shields the private property from executive action, but it does not shield from the legislative action. In the event of the violation, party cannot directly go to the Supreme Court for the enforceable of the fundamental rights, which are under the Article 32 if you go to the Supreme Court. But party High Court जा सकती है under the Article 226. And there is also no guarantee the right to the compensation. ये हो भी सकता है मिले या ना मिले. And it states that no one's property may be taken from him or her unless he has legal authority to do so. So एक proper process, due process चाहिए होता है इसके लिए. Now let's discuss our today's prelims practice question that right to property is a fundamental right, constitutional right, natural right or judicial right. Question 2. Under which amendment right to property as a fundamental right was abolished? 41, 44th, 42nd, 54th. This was all about today's video in session. Thank you. Have a great day and stay tuned with ANALYST IAS for a better preparation.